What's up, guys? Hey, so before we begin, where are you guys from? Send it to all attendees. Put your agency and send it to all attendees, please. What's up, Mike? I know you, Mike. And good. I'm glad you guys are sending this to all attendees. Hey, Catherine, how was the search and seizure class? With Ann, right? Didn't you just attend it recently with Ann? Good. Yeah, she definitely knows her stuff. Yep. 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 Ann's legit. What's up, Ari? Yeah, keep it going. You guys are doing a good job too, sending it to all attendees. What's up, James? All right, let me see here. I'm looking at some stuff before we get started. If you just joined us, please send your agency to all attendees. Let's see where you guys are from. All right. Hey, Lawrence, what's up, man? So Lawrence is actually, send it to all attendees. Lawrence is from my old agency, Nevada Highway Patrol in Las Vegas. Do we know each other, Lawrence? Okay. When'd you, just out of curiosity, when'd you get on? I think you're from Del Padre's academy, right? He was the Del Padre was the academy instructor, I think. All right. All right. Oh, good. Okay. Copy that. All right. Copy that. All right, cool. All right, guys. So check this out. Here's how we're going to do it. So James, welcome. Do me a favor. Make sure you send it to all attendees. All right. So what we're going to do is a little bit different this week. All right. Turn off my phone. Okay. We're going to do it a little bit different this week. So I'm going to, well, I'll explain to you in a second. All right. So first of all, let me get out the disclaimers and stuff. So if you're going to ask a question, okay, if you're going to ask a question, please make sure, thanks, Lawrence, that it goes to all panelists and all attendees. Otherwise, nobody will see it, right? So if you don't change that setting on your, if you don't change that setting, then nobody sees it, and we all want to know where people are from. Okay, perfect, just like that. So welcome to Search and Seizure Saturdays. I think you're going to like this class. I got some good information for you. So first of all, my name is Anthony Bandiero. Let me kind of introduce myself for those who do not know me. I'm an attorney and senior legal instructor for Blue to Gold law enforcement training. This is what I do for a living. I have the honor and the privilege to train police officers around the country in search and seizure. A little bit about my background. So I was a full-time police officer. I was a trooper sergeant with Nevada DPS. I already see that a few of my brethrens are here from the same department. So I worked in Las Vegas with Nevada DPS, mainly Highway Patrol, or actually only Highway Patrol, for approximately 10 or so years. And then I also worked for a small department up north. So I have nothing but good things to say about my experience with DPS and also with the smaller department up north in Elko, Nevada. I've made a lot of mistakes though. And, you know, one of the reasons that I'm really motivated to train officers in search and seizures, I don't want you to make the same mistakes that I did. So that's a little bit my experience, about my education. I have also worked very, very hard, and I'm still working hard to have the answers to your questions. Okay. I have 2 degrees from Harvard University, a master's and a bachelor's. I went to Gonzaga School of Law, and and I'm an attorney in Washington State and also New Jersey. So, but I represent cops from around the nation in various legal issues. All right, John, do me a favor, resend out to all attendees. I'm glad that you're here. Okay, so if you want to know more about my background, just go to bluetogold.com and you can see the website. All right, so and see my background, my resume. So here are the 3 books that I've authored. The first one is the Search and Seizure Survival Guide. I'm telling you, thanks, John. This is the best search and seizure book out there. It's written for you. It's not written for prosecutors and so forth. It's written for police officers. So therefore, it gets down to business, right? It talks about those things that you need to know to win your cases in court and also defend yourself against liability accusations and so forth. So it's the most popular search and seizure book in America, and by far tens of thousands of these are in the hands of police officers around the country. The Bulletproof Report Writing book and the RS and PC Pocket Guide is my attempt to add some clarity to report writing, especially for articulation. That's what I'm here for, okay? A lot of report writing courses are mainly focused on grammar and punctuation and spelling, and that's all important. Trust me, I'm just as guilty as everybody else when sometimes I find a lot of mistakes in my own writing. But the problem, though, is that cops are not losing their cases or getting successfully sued because of a misplaced comma. You got to learn how to articulate. You got to learn to go to court and describe to the court why you did what you did. That's what those books are for. And Catherine, I appreciate your feedback on that. And so Misty as well. Thank you. All right. So get those books. They're on bluetogold.com. They will help you. Guarantee it. Disclaimers. Laws and agency SOPs may be more restrictive. I'm going to share with you some issues that came up from some questions, and some of them have to do with some state law stuff, but the conversation is still going to move the ball forward. Second, if you have any doubts about your actions, right, especially whether or not you can do what you're doing under the Fourth Amendment, ask your sergeant, ask your lieutenant, whoever your boss is. That's what they're there for. There's nothing wrong with that. That's what chain of command is all about. And finally, this course is legal education, right? I'm just going to share with you some questions and so forth. It's not legal advice. I do not give legal advice over this medium. If you do need legal advice, go to bluetogold.com and contact me, and we can talk about retaining me for a case that you're dealing with and so forth. All right, your certificate. So I don't know how long we're going to be here. I assume maybe an hour at the most, depending, how much stuff I have and how many questions you have. That's kind of what they're designed for, just kind of a quick hour-long webinar to keep fresh and keep sharp on the latest search and seizure issues. But whatever when you're done, go to the Blue to Gold website and download the certificate that goes with this course. It'll say Search and Seizure Saturdays, and it's a fill in the blank. I think that the cert has an hour and a half as a default, but you can overwrite that and you can change it to an hour or whatever we're here for. Okay, your question. So here's the deal. This webinar was always meant to ask or to answer your questions, right? I'm a guru on search and seizure. Many people consider me one of the best, if not many consider me the best search and seizure instructor in the United States. And so you have this time, right? You have my hour, an hour of my time, my full attention, and ask me your search and seizure questions. Now, I get questions in my inbox almost daily, and some I just, it's hard to answer all of them. So what I want to start doing is I want to start bringing some of the questions into this environment. And I want to share with you what I'm being asked, right? And I want to share with you what the feedback is, because I think, and I'm bringing in questions that I think all of you might have. That's what we're going to do today. But if you have another question or you want clarification, if I can help, let me know. Now, one thing to keep in mind, though, is that I'm a search and seizure expert. I am not a Juan, do me a favor, resend it out to all attendees. To all attendees. Juan is actually from Alabama. I just got back from Alabama. I had a great time. I was in Alabama for a week, and I'll be in Texas the next week, and then I'm going to, then it goes on from there. But okay, so it's good to have you here. Okay, so if some of these issues require you knowing your statutes, right? I do not know all of your statutes. I'm pretty good with certain states because I teach there a lot. I'm pretty good with California and of course Nevada where I worked and so forth. But some places I just don't know your state law. So just remember that I have no opinion. I'm just going to give you a general what I think the law may be, but you're the experts in your law, not me, for statutes. I am the expert in the search and seizure aspects. So, all right. So here's a question that I got. This question comes up constantly. Can I forcibly detain a fleeing passenger during a traffic stop? So imagine that the traffic stop is for speeding. I can, Greg. Greg, do me a favor, resend it out to all attendees, just so people know what we're talking about. And I will at the end of this. I'll definitely talk about that. So what do you guys think the answer is? Can you forcibly detain a suspect, a passenger? Now, let's say that the traffic stop is for speeding. That does not implicate the passenger. But then the passenger takes off running. Can you chase that person down and detain them? Okay. I'm seeing a lot of no's. I'm seeing one yes. I'm seeing a lot of no's. Okay. All right. So but Catherine, the guy took off running. Isn't that suspicious? Right? Isn't it suspicious that the person just takes off running? Right. Blair, do me a favor, resend it out to all attendees. Okay. So here I'm gonna give you, yes, I do believe it would be. I do believe it would be the reasonable suspicion. All right. Let's walk through it. Okay? Let's walk through it. Hey, that's fine, right? That's fine. Right. Brendan, yeah. Okay. So here's an example of what I'm talking about. All right. Let's just kind of see this real quick. Oh, I lost my green screen. Hold on. Hold on. Come on. There it goes. All right. So here's the deal. That's kind of what we're talking about here, right? Does that, because the way that person acted, okay, I'm not talking about tactically. Tactically, I think that the officer is probably shouldn't be chasing him and leaving his car unattended, multiple occupants left in the vehicle. Don't you guys agree? We probably shouldn't chase him. But what if we had a backup officer and the backup officer, right? What if the backup officer chased after the passenger and detained the passenger, do you think what you just saw there, do you think that that would be legal? Yes or no? One second. Do me a favor. Juan, change that to all attendees. Tiffany, all attendees. John, all attendees. Okay. So here's what the Supreme Court has said about this issue. Okay, let's see what Blair says. Blair says there's no reasonable suspicion because the stop was for driver, the DUI. Partner can chase but not detain until okay, but he can chase. You're right. There is no, Blair's correct about that. There is no seizure under the Fourth Amendment until he's caught, right, Blair? That's what you're talking about. But I guess the question for you is the running from the traffic stop, generally speaking, the reasonable suspicion? Is that the reasonable suspicion to detain him? Okay, not in my opinion. Okay, so that's okay. So, and by the way, okay, let's just kind of go through it. All right, hold on. All right, so here's some of the things that the U.S. Supreme Court has said about this issue. Now, first of all, we know without any uncertainty, okay, we know that the U.S. Supreme Court has made it very clear, crystal clear, that the passengers are seized under the Fourth Amendment. Quote, any reasonable passenger would have understood the police officers to be exercising control to the point that no one in the car was free to depart without police permission. So John, I don't think it's, I know, by the way, I'm familiar with the Florida case on that issue. I don't think it's probably, it's not PC, right? I don't think it's the PC. It's just that they're seized under the Fourth Amendment. So actually, how it works in Fourth Amendment, or Florida is a Fourth Amendment state, so Florida follows the U.S. Supreme Court. But here's what we're dealing with, okay? Under Brennan, and let me give you one more quote. This is a case called Maryland versus Wilson. What happened in Maryland versus Wilson is the trooper, the passenger was acting a little nervous, asked the passenger to exit the vehicle. When he exited the vehicle, cocaine fell down on the floor, right? So now he gets hooked up for narcotics, felony narcotics. The U.S. Supreme Court has held that, back up, the U.S. Supreme Court in Maryland also said that the passengers are seized, right? They are seized in the Fourth Amendment, and the reasoning is they said it's de minimis, it's minimal. Okay, so the driver's the one that committed the crime. The passengers are seized as well because it's a minimal intrusion. Because it's a minimal intrusion, they're already in the car. Getting them out of the car is also minimal under the Fourth Amendment. Now, for my peeps that live in more restrictive states, New Mexico and Oregon and Washington and Massachusetts and New Jersey, remember, your state's going to be a little different. You're probably going to need something called heightened caution or something like that in order to bring the passengers out. But we are talking about just the general rule here. Okay. So we don't have probable cause for the passengers. We just have them. They're just involved in it. They are seized under the Fourth Amendment. But Maryland, during the Supreme Court case, they specifically asked the U.S. Supreme Court to also hold that we can also use force if we need to keep people on scene. And the U.S. Supreme Court did not take up the offer. Here's what they said. Maryland urges us to go further and hold that an officer may forcibly detain a passenger for the entire duration of the stop. But respondent, that's the defendant, was subjected to no detention based on the stopping of the car once he had left it. So he's no longer free. His arrest was based on probable cause to believe that he was guilty of possession of cocaine with the intent to distribute. The question which Maryland wishes answered, therefore, is not presented by this case, and we express no opinion upon it. So we're kind of in limbo here, okay? We're kind of in limbo. On one end, the Supreme Court has made it clear that the passengers are seized under the Fourth Amendment. On the other hand, they have not said what kind of force we can use to keep them on scene. Therefore, we're going to have to reach out to to circuit cases to find out how they're dealing with this issue. Enter United States versus Bonner. So Bonner was an occupant of a stopped vehicle. He's a passenger, right? He's not implicated in any crime. The driver was it was a traffic violation. Bonner ran from the scene of a legitimate traffic stop without authorization or consent of the officers. During such a stop, a police officer has the authority and duty to control the vehicle and its occupants, at least for a brief period of time during a lawful traffic stop. Bonner prevented Officer Stewart from controlling the stop by running from the vehicle before the purpose of the stop was even announced, right? So again, they're kind of talking about that cops do have authority to control this traffic stop. It is inherently dangerous, right? There's a lot of things going on. I mean, before you even find out what's going on, people running from the traffic stop, that is going to obstruct you. It's going to cause safety issues and so forth. So the Third Circuit is the only case so far that I can find directly on this issue with the people running from the car. Here's another quote. Okay. In this case, however, Bonner did not simply flee upon noticing police, nor did he simply refuse to cooperate during a consensual encounter. They're saying those things may not be enough. But Bonner fled from a lawful traffic stop before the officers had the chance to announce the purpose of the stop. He continued fleeing despite repeated orders to stop, and he did not stop running until he was tackled by Officer English. Bonner's flight from a lawful police traffic stop, where that flight prevented the police from discharging their duty of maintaining oversight and control over the traffic stop, provided the officers with reasonable suspicion to stop Bonner for further investigation. All right. So let's kind of walk through. Let's see what your feedback is. All right. So Blair says chasing misdemeanor runners and then using force on them to detain is a recipe for losing your job. War on Cops lecture. I'm going to give you. I don't know. I mean, it's a little bit different though. I mean, I think that may be, true for people leaving the stop, just leaving the stop. Hey, I don't want anything to do with you guys. I want to leave. I do think we got to be careful there. And I think you guys will all agree. I think everybody agrees that if you have nothing besides the person just wants to be left alone, have a reason to detain them. But what the question asked of me was the running issue, right? Just like you saw in that video. Does that sound reasonable to you? I mean, the Fourth Amendment, do what you want, by the way. I'm not, I don't care. Either way, I don't care. It's your discretion. Not, I'm not telling you what to do, right? I can't tell you what to do. I'm not even I'm not your legal advisor. But when you look at the Fourth Amendment only prohibits one type of search and seizure, the unreasonable one. Does it seem reasonable to detain a guy who's trying to flee a lawful traffic stop? I think the answer is yes. I think that if the Supreme Court looked at that video and saw this guy taking off running from that traffic stop, that the officers have lawful authority to detain him and to figure out why is he taking off. I think the answer is yes. That's me. But you do what you want, right? But I have authority on it, right? I have this is a Third Circuit case that's directly on point on the issue. So let's see. So officers can detain the passengers in a traffic stop for reasonable. Okay. So first of all, let's kind of discuss what. So passengers are already seized, right? We know that from Maryland versus Wilson, Brennan versus California, Arizona versus Johnson. Those 3 U.S. Supreme Court cases have already made it clear that the passengers are seized under the Fourth Amendment. They can also challenge the reason for the stop. But it seems, even though the U.S. Supreme Court did not use that Maryland case to also answer what kind of force can be used, the reason they're not going to answer is because those facts are not before it. All they're going to do if they're trying to answer that question is hypothesize, right? Oh, what if the guy ran? Well, hypothetically, they're not going to do that. The U.S. Supreme Court is going to wait for a case to come before it with all the facts, with all the arguments already, figured out, who's telling the truth, who's lying, all that stuff at lower courts. They're not going to hypothesize at the Supreme Court level. But I can't see them saying, hey, guys, the passengers are seized under the Fourth Amendment, but you have no way in other words, they're saying they're seized for the duration of the traffic stop. But then if officers want to use a reasonable amount of force to keep them there, they're going to say no. It's an empty promise then. If that's the case, then they're not really seized, are they? Right? Then they're not really seized in reality. If they can just get up and just walk away anytime they want. Every case, okay? Every case, I shouldn't say every case. There's a few, but most of the cases that I've read that dealt with this issue have held that police may order people to stay. And it seems to me that comes with a reasonable amount of force as well. So to answer your question, Lawrence, so officers can detain a passenger in a traffic stop for reasonable suspicion. That's not quite accurate. The Supreme Court did not use those words. They just simply said that they are detained as a matter of course because of it's a minimal intrusion upon their liberty. Okay. Blair, I think he has a good point. And Florida is a little bit more. Florida does have a case on this from the Florida State Supreme Court. Now, best practice, right? I think we all agree, right? Even though passengers are seized under the Fourth Amendment, use good judgment and have a reason to keep them on scene, right? Right. So Misty says the use of force is not minimal. Well, here's the other thing that it's coming into play, right, Misty? When they leave and they are detained and you have a right to keep them on scene for your safety and for just to, carry out business, and you order them, right? You order them to not leave. Well, would they be violating your obstruction law under your state if you're giving them a lawful order because they are seized? That's how, yeah, Mark also, so that's how I slice that. That's how I handle that issue. Because Misty, it's a very good question. Use of force is not minimal, right? Use of force is not minimal, but the obstruction is where you get the force. So there you go. Again, this issue is it's a hot topic. It comes up a lot. Okay. Don't think I'm making this sound, it's obvious. The answer is it's black and white. No, it's not. It's not black and white. Judges do struggle with this one because the passengers are referred to as blameless, right? They're blameless people. They don't, at the point of the traffic stop, they have not done anything. They're blameless. They're just there for the ride. But these cases that I'm talking about too, by the way, they have upheld these. The passenger always did something else. They are extremely nervous. They made furtive movements. They tried to run from the traffic stop. The traffic stop occurred in a high crime area. Maybe there's some gang indicia. There you go. Actually, I think Misty just said that. There we go. Actually, Misty beat me to the punch. That's what I'm looking for, okay? If all you have, is vanilla, a guy who is saying, hey, look, I don't like police. I want to be free to go. And they're on a city street. There's a sidewalk there. They're not violating any other ordinance like walking on the highway or state law, right? You can't walk on the highway, a controlled access highway. They're not violating any law. And you have no other articulation that they could be a danger to you, then maybe you should let them go. That's what I would do. I would let them go. If I'm going to order them to come back and potentially write a check that my mouth better be able to cash, like, hey, come back here, or I'm going to put you in handcuffs. I'm going to go to court with something else going on. That's me. Do you guys agree with what I'm saying here? Does that kind of make sense? All right. So I think we're all on the same page. We want to make good case law, right? Especially with the war on cops. Judges are not giving us a lot of latitude anymore. Okay, here is another question that came up. Does a passenger commit a crime if he or she lies about their identification? What do you guys think about that one? Hey, what's your name? They give you a false name. Okay, this one you guys seem pretty in agreement, right? Okay. Okay. So now right. So the weird thing about this is, well, we'll go through it. Now, the officer who asked this question is from Texas. So I'm going to base my answer off Texas law. You know what? The way your law is written does matter here. It does matter. But let's kind of go through it. All right. Because even in California, by the way, PC 148, it's kind of confusing a little bit on this issue. It's not, from my understanding of obstruction, which is 148 in California, it's not the actual giving. If the person is not suspected of any crime, or there's being detained, the way they interpret it, it's not the actual false ID that gets them in trouble. It's the delaying your investigation. I think that's how you guys interpret it as well. It's that significant interference with your investigation. My California cops, is that also kind of how you see it? It's not in and of itself the false ID, because the way the law is written, it doesn't talk about false ID as much as talks about the obstruction part. Right. Yeah, so it's a little confusing in California. In California, it's just a little different than most states. In most states, they have their laws are written like this. And again, California is a little different, but I think in the end, we get to the same result. Okay, here's what Texas says. That's right. That's right, Dimitri. Right. I'm with you on that one. Okay, so here's what Texas says. A person commits an offense if he intentionally gives a false or fictitious name, residence address, or date of birth to a peace officer who has, right, lawfully arrested the person. That makes sense. I think that's every state. Lawfully detained the person, or requested the information from a person that the peace officer has good cause to believe is a witness to a criminal offense. I want to make a kind of a point about this last one. I would not overly, especially if my Texas people, right? I would not go hog wild on that last one and say, oh, if they witness it, they have to identify themselves. I read this to be the way is to be a material witness. The reason I say that is because I have had Texas officers come up to me and say, hey, Anthony, what do you think about this practice? I know you said that we cannot demand ID from a passenger. You guys all know that, right? If the passenger is not taking off running, is not, doing anything else, they cannot be forcibly identified. You guys know that. But what some clever officers have said or interpreted is that if the driver gets pulled over for speeding, well, they're a witness to speeding. You see where I'm going with this? They're a witness to speeding. Therefore, under Texas Code 38.02, they have to identify themselves because they witnessed the speeding. Do you guys buy that? Do you think a court would uphold that we can demand ID under that logic? I mean, I have to say, it's clever. It's clever, right? I will give my cops an A+ in creativity, but I give them a C minus, right? I give them a C minus in constitutional law. That's not going to work. That's not going to work. So what we're talking about here is, if you have a similar statute, we're talking about material witnesses. These are people who you cannot live without. These are people who are going to be a key to your case if you go to trial. That's who you use this against. Right. Okay. So let's talk about the lawfully detained part. So here's what the passenger is arguing. Okay. The passenger is saying, look, remember in Maryland versus Wilson and Brennan versus California, the U.S. Supreme Court uses the term seized, right? They don't use the word detained for the passengers, right? I'm good. I'm glad you guys have found this valuable. That's good. So, in fact, when I have a video on YouTube about this issue, and I'd say that, look, when you are, pulling over that car, you're not really detaining the passengers, you're seizing them. And I like that distinction because it just kind of gives us a mental note that, yeah, okay, they're seized, they're not free to go, but that doesn't mean you get to treat them like a criminal, right? The driver is the one who committed the infraction typically. Now, if the passenger is the one that threw a cigarette out the window, not wearing a seatbelt, you believe he or she has a warrant, of course, then they are the target of the investigation. And then what happens to the driver? Then the driver is almost treated like the passenger. In fact, I actually teach that if you pull over the passenger because he flings a cigarette out the window, and you ask the driver for his driver's license, and he says, I don't want to cooperate with you, I want to be left alone. You have a problem with the passenger, take it up with the passenger. I actually teach that push comes to shove, I don't think you can demand that driver's license. I don't, because what did they do? I may be wrong. Some courts may not agree with that. Some courts may think it's part of the traffic stop. But I think constitutionally they're in the same boat as the passenger. That's what I teach. Whatever you guys want to do is up to you. But I wouldn't I wouldn't push it. Now, if the driver says, "Hey, I don't have one on me," or "I don't have one," well, then that's a crime committed in your presence. So then you go from there. All right. So what the passenger is saying in this case is that because the U.S. Supreme Court has said that I am just seized, I'm not detained, Texas law doesn't apply, and the court does not agree. Here's it's a little wordy, but let me see if I can kind of, flush out what the court has said here. Okay. The evidence shows that the officers observed the vehicle in which appellant, right, that's the defendant, was a passenger engaged with which appellant was a passenger engaged in a traffic violation, and they stopped the vehicle because the officers had an objectively reasonable basis for making the traffic stop. Appellant was lawfully detained. They're going to use the word detained here, not seized, like the Supreme Court does. Detained at the inception of the stop. Appellant gave the false identification statement at the very beginning of the traffic stop, and thus the stop had not been unreasonably extended. So it's not like we're not doing some other investigation. That's part of routine. I mean, cops routinely are allowed to ask passengers for their identification in most states. Oregon and some of these other ones are a little bit more restrictive. So we hold that the evidence was sufficient for the trial court to conclude beyond a reasonable doubt that appellant was lawfully detained when he gave the officers a false name. Therefore, under the statute, even though he's a passenger, he did not do anything wrong. When he decided to go down the false ID route, he committed a crime in the officer's presence, which is actionable under Texas state law. There's one more quote here. Oh, that's it. Okay. Absolutely. Yep, Lawrence, you can absolutely ask for passenger's ID in Nevada. No doubt about it. No doubt about it. If they refuse, they don't have to comply. They can just say, I want to be left alone. But if they do play ball and they give you information that proves to be a deception, then you potentially have a crime committed in your presence. Okay, here's another question. Now, if you have any more feedback on what I just talked about, let me know. So here's another kind of question involving passengers. Can an officer demand that the seized person, the passenger, okay, this is the passenger, identify him or herself if the detained person has a no contact restraining order and the officer believes the seized person is listed as the protected party in the restraining order, okay? This is assuming that the detained person will not voluntarily provide the information to the officer. So now I'm going to leave it up to you. Remember, here's what we got. We have a traffic stop for speeding. We run the driver. The driver comes back with a restraining order against him. There is a female in the vehicle. For example, I don't have all the details of what but the female in the vehicle generally matches the description on the restraining order, thinking that he is violating the restraining order. The passenger will not identify herself. Can you demand the ID from the passenger? What do you guys think? John, do me a favor. John says yes. Put that, change your chat settings to all attendees. Give me some more feedback here. Great. A lot of you guys are saying yes. Jonathan, do me a favor. Resend it out to all attendees. Nobody can see it. Okay. All right. Well, here's the deal. Here's the problem here. Here's the problem here. For those who are saying reasonable suspicion, the problem is this. The passenger, the passenger is not suspected of a crime though, right? I mean, am I wrong here? Can we charge, thanks, Jonathan, I'm gonna answer that. Can we charge the victim, the protected party, with any crime if she is consensually hanging out with the guy with the restraining order? Yes or no? Can we charge her with any crime in your state? Wade says yes. Wade, that didn't go to everybody. Wade, in your state, you believe that they're committing a crime? My mother says yes. Okay. I don't see, I think you can, right? I think the victim can, right? If I'm wrong, I have never really had this issue tested in court, but I've never seen an issue on, I've never seen a case on it. What the restraining order, protects the victim. It makes it illegal, right? If you read it, it says that the male, for example, cannot be around her under these terms, right? So I just don't see how you can drag the female in court and hit her, do some kind of contempt charge or whatever, because I don't think that's a law. That's right. So what I'm trying to say here is this: if she is the victim, then you cannot force identify a victim. Does that make sense? There is no law that I'm aware of, and there is no constitutional principle that I'm aware of that you can force ID a victim of a crime. Is that you guys see where I'm coming from? Right. I think I'm with Curtis on this one. Right. There is now what helps you though is you do many states, and there's a constitutional principle as well to uphold this, but many states do have a ID requirement for who? Witnesses. Witnesses. Okay. So if you have a material witness, like I said in the Texas statute, if you have a witness who is a witness to a material, who's a material witness to a violation, you can demand ID from that witness in order to give it to the prosecutor. The next question is the victim also a material witness in the violating of the RO, the restraining order? What do you guys think? Okay. So I think the answer is also I'm leaning towards yes, but even though I'm telling you I'm not positive. But what I do like what people are saying, in Arkansas and this, is I would before I would do my best to try to get her picture, her whatever, just I would do my best to not make an arrest or something. I probably wouldn't make an. I don't know. Who knows what I would do here. I would want to say, that's right. But we're talking about the failure to ID part as a witness, though. I don't know what I would do. I guess I would have to read this, the restraining order. I probably have to call my bosses and maybe even call a district attorney and say, look, what do you want me to do here? That's what I would do. Because the other thing too is, don't forget. Can I also share one other point? You're kind of stuck between a rock and a hard place, aren't you? What happens if she refuses to ID herself? Which, by the way, is a little suspicious, right? Maybe she is the victim. Let's say that she refuses to ID herself. The description generally matches on the TPO, the temporary protective order, or whatever you guys call it. And then you let them go, and then he kills her. Do you think you may have liability? So I think you're gonna have some tough questions, that you felt that this was her, right? You thought this was her, and then you didn't do enough to enforce the protective order. One thing that I also wanted that I was thinking of when I was reading this question is this. Okay, here's my little final thought on this. If you really think, okay, that it's her, and you really think like the height and weight and the age and and the fact that they are together, and she's not identifying herself. If you really think, if you have a fair probability it is her, maybe you have enough to arrest him for probable cause. That would also take care of the problem. Yeah. Oh, you see what John wrote? Absolutely. Whatever you do, again, I'm telling you, that's one thing I think we all agree. Whatever I'm going to do, okay? Whatever I'm going to do, the one thing I'm not going to do is I'm not going to arrest her unless I have a DA telling me to do it. Right, John? Right. I'm not arresting her. I would want judicial authorization to arrest her. Or not judicial authorization, that's incorrect. It's the DA. But I would want a legal advisor telling me that he or she feels that that's the right outcome for this particular case. I'm getting on that phone. So it's a tough situation. They don't do that in Florida? Right. They don't give legal advice? Well, then you have to get your boss to get involved in. Yeah. Okay, good. I think we'll figure out something. I think that's the only thing these are good conversations. These are tough situations. Use good judgment. Be as diligent as you can. But I'm actually, I'd be very surprised if you didn't have probable cause. All right, our next question. It's illegal for them to give legal advice. Wow. I did not know that. That's crazy. Is that's interesting to me. Why would they not give? I don't really see that too much, where your prosecutors cannot give you legal advice. Okay, so there we are. Tough situation. You guys are having some, you have some better ideas about maybe how to handle it. Okay, so let's talk about this question. You mentioned in the video, so this is a YouTube video, okay? So you mentioned in the video that if an officer asked the driver, whom would be considered seized because the officer made the vehicle stop, so based on the RS for the passenger. Okay, so I guess what I'm trying here, I gave a little scenario. If you stop the car because of the passenger, okay, and then you ask the driver, do you have a driver's license? And they say no. Then the officer has PC that a crime has been committed due to the driving without a license. That is true. I already kind of mentioned that. The question I have is, isn't the driver not obligated to tell the truth to an officer during a seizure of this sort, because they have, not really detained, as we kind of going back and forth on these issues? I'm viewing the seizure as being equivalent to a consensual contact. During consensual contacts in California, the subject is not obligated to provide truthful information to law enforcement. Okay, that is true. Actually, that's true in many states, not just California. People generally do not have a legal obligation to tell you the truth during a consensual encounter. But this is different though, right? This is not lying. This is not saying this is lying. I mean, this may be lying, but this is not the kind of lying that I'm talking about. For example, in California, in any state, hey, can I talk to you for a second, sir? Hey, yeah, what's up? Hey, blah, blah, blah. One thing leads to another. Hey, where do you work? And I say I work at Walmart, but I really work at Target. That is a lie. That is no crime, right? I mean, that's what I'm talking about. But if the driver voluntarily says that they have no driver's license, either A, on their person, or they're implying that they don't have one, period, they've told you something that is a crime, right? So they can shut up. They can be like, hey, look, I don't want to talk to you. You have a beef with the passenger, take it up with the passenger. But if they voluntarily say to you they have no driver's license, that is a crime committed in your presence. Now you have probable cause as to them. Do you guys agree? Yes or no? Okay. That's okay, John. You're good. Yeah. I appreciate that. Okay. Yeah, interesting, John. Yeah, that's good to know, by the way. That's really, really good to know. Okay. So that's what I have for you guys. So we have about 8 minutes left. That's kind of what I'm looking for. I think this is a good, I think you agree that this is a good use of your time, right? These are an hour. We answer some questions. We get some, we try to figure out situations that you guys are facing out there. Good. Do you have any other questions that I can answer before we leave? And I'm glad, I appreciate the feedback too. And I'll make sure that you guys, also guys, if you, hopefully you can attend some of these online classes, right? Okay. RS versus PC. Oh, and also we have drone. I want to talk about drones because somebody cannot attend my drone training, and I want to give you some feedback on that. Okay, RS versus PC. Now, actually, by the way, I have a video on this. 1 second. Let me see if I can pull it up real quick. Okay, Jocelyn, ask it while I look up this. Ask it while I look up this link. Okay. So that link, okay, let's go through it. Okay. So that link I gave to you is an 8-minute video all about the answer to your question, but to generally give you a quick difference. Reasonable suspicion is for crime prevention. Probable cause is for crime apprehension. That's one way to kind of look at it. Reasonable suspicion is all about preventing people from committing crimes before they start, right? That's what Terry versus Ohio is all about. Remember, Martin McFadden, 38 years on the job with Cleveland Police Department. And he's seen Terry, Katz, and some other, his buddies on the street corner going back and forth in front of that convenience store. Ultimately, when McFadden detained Terry and asked him, "Hey, what are you guys doing here?" Because McFadden thought they were about to commit an armed robbery, and then they mumbled an answer, and they then Terry patted him down, got the weapons off of him. Terry was convicted of concealed weapons charges. He was not convicted of armed robbery or attempted armed robbery. But that is the epitome of what reasonable suspicion is all about. But that's the purpose of it. Now, how do we get there? The other thing I want to share with you is that reasonable suspicion requires current here and now facts. Okay, you cannot just stop somebody because they have a prior history and the only thing they did was go to a known drug house. You're close, but that's not going to do it. You need something about why do you think this person is committing that crime here and now? They go in with empty-handed, they come out within 2 minutes with a bag in their hand. Something, and they have previous history and so forth. But watch that video. I go into detail, and of course, probable causes, facts or circumstances that would lead a reasonable officer to believe that a crime has been committed and the person under arrest committed it. And then reasonable suspicion is facts or circumstances that would lead a reasonable officer to believe that criminal activity is afoot and the person detained is involved in it. Here, I'll give it, there's, did you guys, oh, I see the problem. Sorry, my bad. Hold up, my bad. There it is. See, I actually did this thing that I tell you not to do, which is I sent it to all panelists. It didn't go to everybody. Anyway, okay, so you're welcome, and that's a shorty right there. All right, so where was the next question? I have a question going back to okay. So Jocelyn says if she doesn't want to ID herself, there is a database that has the protective order and who is the protected person. Given that info, you can look her up. Probably in most databases, in some databases, the protected person's name is on the order. Correct. So I think we can figure this one out. Is that what you're trying to say, Jocelyn? I agree. I think we can figure this one out. Yep. I agree. Okay. Oh, and then finally about drones. Here is the deal with drones. First of all, technology is always ahead of the courts, right? The courts are behind the technology envelope for about 4 or 5 years. So drones being a big deal right now, it's going to take a few more years before the U.S. Supreme Court starts deciding some case law. So what we have now is we have case law dealing with helicopters and aerial surveillance to apply to drones and how what we can do and so forth. But here's my general rule, okay? My quick 30-second answer. Do whatever the public can lawfully do, right? Do whatever the public can. Hold on, somebody just wrote me. Well, man, definitely take care of that, and I appreciate your feedback, and hopefully I'll see you soon. Hopefully everything's all right, man. Okay, so do whatever the public can do without violating any laws. So you got what part? What's the FA? Is it Part 107 for drones? You guys tell me, but whatever the drone pilot license, it's part something, right? But the 400-foot rule and not being, too close to people or other aircraft and so forth. don't violate any state law, right? Don't violate state law. A lot of states have drone laws. So if you're doing that and you're also not being overly intrusive, right? If you're not being overly intrusive, like you're not flying over the guy's backyard and inhibiting his usage of his airspace, and he's out there, hanging out with his family and so forth. You got this drone overhead. You can't do stuff like that. But as long as you're being reasonable, reserved, and you're not using high-tech components of the drone, do not use thermal imaging. Do not use high-tech, magnification to look into people's windows. You should be fine. But even, right, part 107, right. So John also mentions, though, that states do have their own rules, right? Like Florida. California has their anti-paparazzi legislation, and how does that apply to police? Some states say police can only use the drone under exigency. Now, I would say, John, you probably can, use them with judicial authorization, perhaps exigency too, right? If you got somebody who's escaping police, exactly, right. So, but if you do not have those rules, do whatever the public can do. And I would put that in a report that, and maybe as clear as that, I observed the stolen car in the backyard while I was flying above in a park. I flew the drone in a manner consistent with how the public flies drones in that area, or could fly a drone in that area. That is what I think the courts are looking for from a constitutional perspective. But you can't violate laws either, so that's another factor. I hope that helps. That's just my 30-second elevator speech on drones. I do have an hour and a half webinar on technology searches. I highly recommend that you take it. It's I think it's very interesting. With that said, I'm going to get gone. I appreciate you guys coming here. I do got to prepare for class next week, and I got some new research I got to do. So you're welcome. Please, you're welcome, Mike. Please do me a favor. Send these out to people. I would like to get more people here just to make sure it's worth everybody's time and get the feedback here. So please spread the word. If you want to pay me back and you want me to keep doing these, all I ask is you spread the word. Then, I want to reach as many people as I can. Join the YouTube channel. I'm putting new videos on the YouTube channel every single week. So hit subscribe. That really helps me. And that's it. And check out the new website, by the way. You're welcome, Lawrence. The new website. I don't know if you guys have seen the new website, but we hired an artist to draw a bunch of cool illustrations for all the header images. Pretty badass. You're welcome, Mama. You're welcome. And thank you for being here. So I love what I do. I have a dream job teaching cops and law enforcement. Keep your chin up, keep safe, and hopefully I'll see you at one of my live classes. Lawrence, do I know Sergeant Del Padre? Sergeant Del Padre is my academy mate. We went to the academy together in 2005. So tell him I said hello. I definitely know who Del Padre is. We worked together for many years. Okay. Let me know. So helicopters and drones can fly over somebody's helicopters and drones can fly over somebody's helicopter or somebody's backyard. But the key is the problem with the drone. Here's the problem with the drone, okay? Drones have maximum heights. Helicopters have minimum heights, right? So helicopters, let's say it's about 500 feet. You got a 100-foot buffer between the UAVs and the helicopter. So 500 feet above somebody's backyard just flying over is not, it's going to be, you're at a minimum height. The problem though with the UAV is you can't fly super high over their backyard. Otherwise you're violating Part 107. That's my concern about it. Maybe you fly at 350 feet above the guy's backyard and you're fine. But you see, that's what, if that is, I did, Lawrence, the answer is yes. The answer is yes, but I actually retired. Technically, my badge, my retirement credentials is out of the Elko Police Department because I left NHP and went to Elko, and that's when I retired of Elko PD. But I spent most of my career at NHP. So I know a lot of people at NHP. So you can, so do you see, so who's the, who's my drone guy? Jay Dreyer. So do you see the point that I'm kind of sharing with you on that? That's my concern there, is those minimum maximums. So if you are gonna fly the drone over somebody's backyard, all I can say is be as high as possible. Yes, it's the intrusion. Precisely. It's the intrusion. That's what they're gonna look at, by the way. How intrusive were you with that drone? That's why I do like it when officers are not above the guy's curtilage. Then there's way less issues. Does that make sense? I mean, if you're above a park, how can you be intrusive? I mean, the guy doesn't own that park, and you're not using magnification and you're not using thermal imaging, then how's it intrusive? That's my opinion. But if you go over the guy's backyard, then we have the argument that you're interfering with his use of his property. All right, guys. Thank you for sticking around. That's right. Joseph also says the drone is much more intrusive. It's true. Yep. All right, guys. Thank you so much for being here. You're welcome, Dreyer. And have a good day. Yep. Have a good day. Enjoy the weekend. Also, I'm putting the webinar link, the webinar link for your cert, just so you know. Hold on, blue to gold. There you go. All right, guys, have a good weekend. Yeah, Lawrence, did you see that? Did you see the URL I just put in there? That, and also, yeah, what's September 11th? Good point. Hopefully you guys will come back on Friday. Yep. What is Friday? You don't see it? Did I do that again? No, hold on. No, that went out there, but hold on. Here we go. Doing it again. Okay. You see it, Lawrence? And then on Friday, hold on. I'm going to tell you what webinar we're having on Friday. Oh, it's not. Yeah, it won't let you click it because I didn't make it a. I can fix that. Hold on one second. I can make it so it clicks. Let me just get it from the web from the. There you go. And then Friday, guys, for those who want to join me on Friday for a webinar, it's going to be Oh, that's a good one. Mastering consent searches. Okay, mastering. Let me just give you guys a link to that one too if you're interested. There you go. Mastering consent searches on Friday at 1 o'clock. That's going to be a good one. All right, guys. Stay safe.